So a new case is seeking Supreme Court review. This case involves whether or not firearm magazines are in fact firearms parts protected by the PLCAA, and whether companies that make these types of magazines can be sued because of third-party criminal conduct. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again take up Second Amendment cases, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for an EDC knife. And just recently, Kershaw dropped some of their new line of knives, their new 2023 line of knives, and I carried their Iridium knife every single day as my EDC. And right now, if you go to their website and you order using the code 23scholar20, you can get 20% off of your order and free shipping on orders of $100 or more. So head on over to Kershaw Knife, pick yourself up a quality EDC knife, and use that coupon code. As I mentioned in the intro, in this video, we will be breaking down an interesting Second Amendment case, which is now seeking Supreme Court review. The case we're going to be talking about is called KCI versus the 8th Judicial District Court of the state of Nevada. In this case, a manufacturer of various parts, including firearms magazines, was sued because of one of their magazines being used in a criminal action. This whole lawsuit revolves around the PLCAA, also known as the Protection of Lawful Commerce in Arms Act, and whether or not KCI as a company can be held liable for third-party criminal conduct. This case, of course, could be very critical for protecting all firearms companies and all manufacturers and dealers from these types of frivolous lawsuits, and also the current agenda that the Biden administration has been putting forward to want to weaken the PLCAA's protections. Now, the facts surrounding this case, which led to this lawsuit, are actually really interesting. KCI is a company that manufactures, imports, and distributes magazines to wholesalers for semi-automatic firearms, including AR-15s. I believe they also make other products as well. On August 4th, 2019, an individual criminally used these products by KCI, used one of these magazines to perpetrate a shooting. The individual had obtained the magazine via a second individual, so the individual perpetrating the crime didn't actually even purchase or obtain it on their own. They got it from a second party who purchased it on their own. The second individual who gave that magazine to the individual in question has himself now been criminally convicted of being a person in possession of a firearm, being an unlawful user, and also making false statements regarding the firearms. The family of the victims of that shooting, well, in response to all this, decided to file a lawsuit against KCI based upon its allegedly negligent manufacture of these magazines that were then used in this crime. KCI subsequently moved to dismiss the lawsuit based on the magazine being a component part of a firearm, and since it is a component part of a firearm, they should therefore be entitled for complete immunity and protections under the PLCAA. This case was originally before the 8th Judicial District Court in Clark County, Nevada, and on review, that court held that KCI's magazine was not a component part of a firearm eligible for immunity under the PLCAA. Therefore, the court there denied KCI's motion to dismiss the case because they said that magazines are not a component part of a firearm. KCI, in response, then filed a writ of mandamus up to the Nevada Supreme Court, and they alleged that the lower court clearly committed an error in that motion to dismiss because a firearm magazine, in their eyes, is a component part of a firearm which is afforded protections under the PLCAA. However, even on review, the Nevada Supreme Court denied KCI's petition for a writ of mandamus. Now, that has now led to KCI, this company, filing a writ of certiorari up to the Supreme Court, and they're asking for the Supreme Court to take up this case and review this issue of magazines and whether or not they are afforded protections under the PLCAA. The question presented to the Supreme Court is simply whether a magazine is a component part of a firearm under the Protection of Lawful Commerce in Arms Act. A very simple question that is presented to the Supreme Court. Now, you may be asking yourself, what is the Protection of Lawful Commerce in Arms Act, or the PLCAA? The PLCAA is a U.S. law that protects firearms manufacturers and dealers from being held liable when crimes have been committed with their products. This is the law that is supposed to prevent a person from suing a gun company, a gun manufacturer, or someone else just because someone commits a crime with that product. The PLCAA defines a qualified product, which is at issue in this case, as any firearm, including any antique firearm, or a component part of a firearm or ammunition, and anything that has been shipped in interstate commerce. This means that the PLCAA is intended to provide protection not just to firearms, but also ammunition and parts as well. However, in this specific lawsuit, the courts found that this case should not be dismissed, essentially that it's going to proceed forward to a trial because the PLCAA, in their eyes, did not protect firearms magazines because they believed that firearms magazines are not a component part, are not afforded the same types of protections under the PLCAA, maybe like a firearm would or ammunition. So the two main reasons that the lower court found that this rifle magazine is not a component part as protected by the PLCAA is because the court said that the rifle in question could still fire one shot without any magazine, and also because the magazines in question were not purchased with that specific rifle. In their petition, KCI goes on to point out that essentially, in this particular case, the lower court correctly cited to a prior District of Nevada opinion, holding that a bump stock was a component part of a firearm under the PLCAA. And there they are pointing to a case called Prescott, and they say in Prescott, the lower court found that a component part means any essential part, and as such, a bump stock was a component part of a firearm since a rifle stock, which includes in their eyes also bump stocks, are necessary for a rifle to fire. So here they're pointing to the fact that there was prior precedent in the state of Nevada that a bump stock is an essential component of a firearm, is similar to a stock, and therefore is afforded protections under the PLCAA. But then the court went on to say, well, maybe bump stocks and maybe just traditional stocks of an AR-15 are essential. But in that court's eyes, a magazine is not essential because you can fire one single shot from an AR-15 without a magazine. Now, I find that interesting because if they're using that logic, that's pretty much true also of any stock or any bump stock, because you don't have to have a stock or a bump stock or anything like that attached to a rifle to be able to fire a round. You don't need a stock at all. You can still fire a round without a stock. KCI argues in their petition that, as this court knows, there have been repeated, long-standing calls for Congress to enact legislative change to address numerous issues related to firearms. However, Congress has largely declined to enact sweeping legislative change with respect to firearms or large capacity magazines. This lack of action has prompted interested parties to resort to using the judicial branch of government to realize their legislative goals. Nonetheless, allowing this type of litigation to persist violates Congress's intent in enacting the PLCAA. Indeed, Congress explicitly determined that imposing liability on an entire industry for harm that is solely caused by others is an abuse of the legal system. The blanket immunity offered by the PLCAA exists for situations such as the case at hand, in which a maverick judicial officer would expand civil liability in a manner never contemplated by the framers of the Constitution. Based on that, the plaintiffs in this case, KCI, are arguing that the Supreme Court must intervene in this case and must take review of this case. So this is a really interesting case involving the PLCAA, and also claims that maybe a rifle magazine is not a component part or is not a necessary part of a firearm or an AR-15, and therefore isn't afforded any types of protections. We will see if the Supreme Court wants to review this case. Traditionally, like I mentioned, the Supreme Court does not like to grant review to cases that are on an interlocutory posture, specifically like this one is. Although I will say that the PLCAA has been in some ways a hot topic. Recently, the Supreme Court heard a case that dealt with liability for social media companies like Twitter and Google. So it'd be interesting to see maybe if they're interested in liability protections for gun manufacturers. Still an interesting case, and if we get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this Judicial news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.